Hi, my name is Mark Silver. I am back for another presentation in forensics. I have been practicing forensics for over 20 years. I work in Manhattan, New York. I'm a psychiatric social worker with a doctorate in psychology. I'm a lawyer, background in political science and other areas. And my predominant focus is family and mental health evaluations for immigration, criminal, and civil litigation lawyers. Today's topic is something which is extremely difficult and quite unusual for immigration defense lawyers, and it is the Adam Walsh Act. I want to note that I have a specific chapter on Adam Walsh evaluations in my book, Handbook of Mitigation in Criminal Immigration Forensics. The subtitle is Humanizing the Client Towards a Better Legal Outcome. It's the 7th edition. It's particularly important here, and I say that because I'm a criminal mitigation expert, which means a core focus of my practice is undertaking evaluations for criminal defense lawyers who have clients who are in a pre-plea or pre-sentence position, and they need a report to examine anything and everything about their lives, explaining their judgment, conduct, challenges, traumas, whatever. I have developed a subspecialty for immigration defense lawyers, and I think I'm the only criminal immigration expert in the United States who does cases for immigration defense lawyers. And that's what we're going to be focusing on today. One of the key areas is the Adam Walsh Act. And I say that because the entire forensic evaluation for the Adam Walsh Act cases is mitigation. The whole thing is mitigation. In immigration, of course, the client is in trouble in some kind of way. The client came in through fraud or misrepresentation, or they entered the United States without inspection, or they're trying to claim harm or human rights violations in the country of origin, which can be a significant hurdle and quite difficult. All sorts of problems that the client has. In this kind of the case, the client is the American citizen, and it is the American citizen who's doing a family-based immigrant petition. And it is incumbent when it triggers an Adam Walsh Act case to evaluate the client to ensure that the American citizen will not be a risk in any shape or form to the family members or to derivatives. And that's what we're going to be looking at today. Criminal mitigation for immigration defense lawyers in the context of the Adam Walsh Act cases. It's important to remember then that the purpose of mitigation is to humanize the client through a sympathetic narrative and induce empathy for the adjudicator by documenting the client's life history and contextualizing the client's conduct. The adjudicator will then identify with and feel empathy for the humanistic background issues and will be more inclined toward compassion and mercy. And for so many of these cases, the American citizen who has had this history of criminal issues, which we'll look at, can't adequately express or explain their behavior. They need a forensic expert to replace their own self-expression. The single most important issue is to disabuse the adjudicator at USCIS or wherever, to disabuse the adjudicator of bias and prejudice and eliminate non-existent patterns that the adjudicator may assume are true or seemingly self-evident in the assessment of the case given the client's criminal history or of arrests or whatever. In other words, the core part of the Adam Walsh Act petition, to repeat, is criminal mitigation. And that's what we're going to look at today. The Adam Walsh Act petition, the Adam Walsh Act was meant to protect children from sexual exploitation in violent crime. Second, to prevent child abuse and child pornography and promote internet safety. It was enacted originally in July 2006 under the George W. Bush administration. The Adam Walsh Act Section 402 also amended Section 204 of the Immigration Nationality Act, the INA, and effectively prohibited U.S. citizens and lawful permanent resident aliens who have been convicted of any specified offense against a minor from filing any family-based immigrant petition on behalf of any beneficiary, unless the Secretary of Homeland Security determines in his or her sole and unreviewable discretion that the petitioner poses no risk to the beneficiary. The American citizens that are applying for family members in the cases I've seen have all been men, and they're all petitioning for their wives. In most cases, the wives are currently living in the United States, and in roughly half the cases, there is a child involved. Usually the wife has a child from a previous relationship. Sometimes the client and the wife will have a child in the present relationship, and more often than not, it's children from possibly both from both of the parents' backgrounds. So I want to look very specifically now at this incredible bar that has to be overcome. USCIS requires an Adam Walsh Act petitioner to submit evidence that demonstrates beyond a reasonable doubt that he or she poses no risk to the beneficiary family members. USCIS considers all known factors that are relevant to determining whether the petitioner poses any risk to the safety and well-being of the beneficiary. Anything and everything means anything and everything. So we reasonably look at all mitigating factors in the person's history, documentations, life, community, extended family members, everything, because we don't want the adjudicator to walk away filling in the blanks. We want an evaluation that's sufficiently comprehensive so that any possible implicit biases are tackled. What I'd like to do now, and this is what I do in regular CLEs, I want to look at the major factors in the analysis and challenges within each factor, biases, and how to comment on them. The first one in the Adam Walsh Act cases is the nature and severity of the petitioner's specified offense against a minor, including all facts and circumstances underlying the offense. What is the inherent bias here? The inherent bias is that it must have been a horrible crime if it was an offense against a minor. The bias is that there cannot be minor crimes against a minor when it comes to sex offenses or other offenses. It's important to understand that all offenses have degrees of severity and they're different in nature. And it's important to examine the context of the offense. And I'll give you one very good example, and I think I bring this up in other places when I do CLEs. I had a case, I've done a handful of these cases. I had a case many years ago where a man was caught in a sting operation. He was in a chat room. This is when chat rooms were still popular. And he had thought he was speaking to an adolescent female, set up a time to meet her. There was some explicit language in the communication exchange. And when he went to meet this supposed individual, the police were there. It was a sting operation. This person had no history of wrongdoing, and this was the first time that he had engaged in this kind of thing, as far as we know. It's important to understand that no person was harmed. This was a police officer posing as a female adolescent. I'm not here to condone my client's behavior. I'm not here to justify it. It's wrong. But it's important to place in context how this is very different factually from someone who really did, in fact, have ongoing repeated sexual communication with a female adolescent and then actually met that female adolescent and then engaged in some kind of sexual behavior with her. And I have had a very similar kind of case where the client did in fact do that. In other words, it's important to differentiate between nature and severity from case to case. And you're going to get some cases in Adam Walsh Act cases that are not only severe, but they're repeated. And then you're going to get the opposite end of the case, opposite end of the spectrum, where cases are relatively minor and it's a one-time offense. The next factor is the petitioner's criminal history, examining if there is violence or criminal issues or abusive behaviors in the client's history. What is the implicit bias here? Right? We looked at the implicit bias in the first category, first factor. What is the implicit bias here? Implicit bias here, I apologize. It is that this criminal issue in the Adam Walsh Act case is just the tip of the iceberg. The implicit assumption is that this client has been caught doing this wrongdoing, but there are many other instances of wrongdoing that he probably engaged in which he was not found out. That is wrong. It's an unfair bias, but it is understandable for the adjudicator to perhaps consider that in these kinds of cases. So it's important to investigate whether or not the crime involved violence in addition to obvious abusive behaviors. Criminal matters unrelated to the present issue at hand must also be explored and mitigated fully to attack bias. Obviously, if it's a client with a clean record, even if there's bias on the part of the USCIS adjudicator, it's obviously very helpful. At the other end of the spectrum, there are clients with multiple arrests of this kind, and you also have clients with unrelated arrests, which can be damaging. The classic example, quite frankly, are clients that have an offense against a minor, but they may also have 2 or 3 offenses for drug-related possession or selling or whatnot. And the adjudicator will look at those drug-related offenses and think, well, this is a person who's obviously unstable. With drugs comes violence. This adds to their concern about the safety of the beneficiary and so on. The next factor is the nature and severity and mitigating circumstances of any arrest, convictions, or history of alcohol or substance abuse, sexual or child abuse, domestic violence, or other violent or criminal behavior that may pose a risk to the safety or well-being of the principal beneficiary or any derivative. The nature and circumstances of mitigating evidence and mitigating circumstances. In other words, the factor considers context. What was going on in the person's life? What was going on in the victim's life? The inherent bias in this factor is that there is no excuse, that there is always risk. The inherent bias is that, yeah, there may have been mitigating circumstances to help us provide insight into why this person did this criminal behavior, but there's just no excuse. And that bias sticks, and because it's a zero risk bar in evaluating these cases, it's very hard to overcome. Alcohol and drugs are always red flags and must be considered very seriously. In cases of abuse, and I've seen hundreds and hundreds, alcohol and drugs magnify the interpersonal risk to the victim, where there's physical, sexual, emotional, cultural, verbal, whatever kinds of abuses the victim is enduring. I had a client in this kind of case where he had led a very healthy lifestyle. He did something that was wrong many years earlier, but just about everything else that surrounded this was positive. He had gone to school, he had a consistent professional career, lived in a community, volunteered at his church. It's not that these positive aspects of his behavior justify or even explain his wrongdoing, but that mitigating circumstances goes a long way to help us understand this person's decision-making and judgment. This is huge in criminal mitigation in criminal court for pre-plea or pre-sentence purposes, and I have completely separate CLEs and YouTube programs I'm posting on them. Because it all cumulatively adds up to how the judge or the DA, for pre-plea purposes, will consider the case. The difference is that in Adam Walsh Act cases, because it's a no-risk bar, the mitigating circumstances have to be crystal clear. They have to really inform the adjudicator and have them give them something to really hang their hat on. The next factor is the relationship of the petitioner to the principal beneficiary and any derivative beneficiary. The implicit bias here on the part of the adjudicator, or anyone, frankly, is that the beneficiary cannot really protect herself. That even if there's a superficially close and loving relationship between these two individuals, and there seems to be legitimate love and care and genuine support and empathy and so on, that the beneficiary cannot really protect herself because of the client's history of wrongdoing 5, 10, 20, 30 years ago. So it's important, therefore, not just to evaluate the client and his history of wrongdoing and mitigating issues, but to evaluate the beneficiary. How long have they known each other, the quality, the scope of their relationship, and so on. I had a Adam Walsh Act case where the beneficiary was here legally. She was working as a surgical nurse in Philly. And I went to the home and I interviewed them. And this was a woman who was very educated, working as a surgical nurse, and her eyes were wide open. She was able to provide a great deal of input for the evaluation regarding the quality of the relationship, how they have known each other. In other words, I didn't just rely on the petitioner. I was relying on his or her spouse just as well. When the spouse, who is an immigrant, has poor English language skills, I strongly suggest getting an interpreter so that we can get detailed information. Although I must say, in the cases that I have, in the Adam Walsh Act cases, the beneficiary tends to have good English language skills. However, the other issue is that the second bias concerns not just the beneficiary, but the derivative beneficiary, that a child cannot protect him or herself. And again, this needs to be looked at carefully also. I do this in many ways. In every Adam Walsh Act case I've had, I do a home visit. Usually I have clients come to my office. In Adam Walsh Act cases, I highly recommend to the clients that I actually go to their home. I want to get a sense of how the child and the beneficiary are living. The quality of the environment, look at the living room, bedrooms, the general neighborhood, and so on. It's important, I think, to give the adjudicator a sense that the evaluator is not just speaking with these individuals, but has firsthand knowledge. I frankly look at this a little bit like, in adoption cases, and I've done consulting in adoptions, where you want to know about the environment as much as you want to know about the individuals. The next major factor is the age and, if relevant, the gender of the beneficiary. What is the inherent bias here? The bias is that young girls are always targets of this petitioner. The bias is that young girls never have the ability, because they are minors, to adequately protect themselves. Age is also a major consideration, especially if the beneficiary child is quite young and less capable of independent decision-making and self-advocacy. Clearly, if the children are older, it's a different kettle of fish. One of the first cases I did was for a woman who was marrying here in the U.S., and she had 3 or 4 adult children. All of them were in the Philippines. All of them were planning to stay in the Philippines. 2 had married. In other words, any benefit as children that they may have in the future would look very different as adults who had attended college, they have professional careers, as opposed to a beneficiary mom who has young children in the scenario where they may be at greater risk because they don't have the ability to self-advocate. So age and gender are very important. The next major factor is whether the petitioner and beneficiary will be residing either in the same household or within close proximity to one another. What is the inherent bias here? Where there is accessibility, there is danger. The adjudicator thinks by virtue of the fact that they're living so close to one another under the same roof, the beneficiary cannot adequately protect herself. Clearly, it's important to have a sense of all the factors that we've discussed, but also supporting mitigation and issues. And I'll give you one very good example. I had a case where a man was marrying a woman. She was living with him in the same home, of course. They did not have children together, but he had 2 children from a previous marriage, and the kids were like 10 and 12 or so, or maybe just a bit younger. They were living in the same community. He had partial visitation. There was zero problem with the children. They were growing up beautifully, academic scholars in school. Just one was in a gifted and talented class. They're playing violin, just doing well, these kids. It gave insight for the adjudicator to understand that, hey, look, here this petitioner has children in the community. The kids are growing in a safe and healthy manner. He has regular visitation. The kids sleep over at his house. The beneficiary stepmom have a good relationship. It gives a much better sense to the adjudicator to say, look, this is a person with a history of proper self-care for the children, so that these children who are living in the same household or community, that proximity is not necessarily something that should be an issue. The last major criteria factor is the degree of rehabilitation or behavior modification that may alleviate any risk posed by the petitioner to the beneficiary, evidenced by the successful completion of appropriate counseling or rehabilitation programs and the significant passage of time between the incident of the violent, criminal, or abusive behavior and the submission of the current petition. What is the bias here? The bias here is that the adjudicator is going to be skeptical that rehabilitation is really effective. That is, the adjudicator is going to think, well, even if the offender attended a rehab program years ago, and even if the offender had gone to counseling for many years and is living what seems to be superficially a proper life, that really rehabilitation is never effective for these criminals, and underneath the surface, the individual has not changed his stripes or colors. In other words, the passage of time does nothing to alleviate sexually deviant, impulsive, or obsessional thoughts, feelings, and behaviors. This is, again, a very hard bias to overcome, and it has to be tackled by looking at various issues. You have to look at the totality of the person's family life and community life, their positive behaviors, their accomplishments. You have to look at their psychological health, emotional stability, physical and medical well-being, and so on. Documentation is crucial. In Adam Walsh Act cases, like in a lot of immigration cases, the rule is document, 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 document. In many of these cases, proper documentation, unfortunately, is not available for many reasons. In regular criminal work that I see, the client has committed a wrongdoing relatively close in time, a few months, a few years. In Adam Walsh Act cases, the person may have committed a wrongdoing 10, 20, 30 years before. And documentation may not be available anymore. Therapists may not be around. Progress notes may not be reviewable, and so on. Having said that, my one major conclusion from all this is that the Adam Walsh Act case must nonetheless be approached as any other criminal mitigation case. And in criminal mitigation, you look holistically at anything and everything positive in the person's background, while also trying to understand if they've experienced any major challenges, traumas, or so on, and providing and fleshing out any and all issues with appropriate documentation and family interviews and supports in order to tackle all of these implicit biases that the adjudicator may have for the major factors involved. One of the great ironies in these cases, and this is extremely important to understand, is that if the USCIS is really interested in safety of the beneficiary or beneficiary's family, then you want to keep everybody together. And let me explain this a little bit. If the person who committed this offense against a child X number of years ago is stable and they're doing well in their community and they have good family ties and they're close with their extended family, they have the same professional career, they go to church and they have these activities. If all of these things are in place, these things serve as therapeutic supports for them. And that's exactly where you want the beneficiary to be. You don't want the beneficiary to be in her country of origin with her husband where these supports are not available. I'll give you a very interesting parallel. I do criminal mitigation cases for immigration defense lawyers. And one of the areas I've done a lot of are DUIs and DWIs. And I'll see cases where someone's been, arrested once or twice or three times for driving while intoxicated, and the person does very well here. They've gone to AA meetings, they have their church, they have their family, and they become respondents in cancellation removal cases. And one of the things I try to explain in my reports or when I testify in immigration court is that, yeah, the person is doing well here and he's being a great father and he's taking care of his American kids and so on. But what's going to happen if he's deported to some small town in Mexico where he doesn't have AA meetings, where his extended family member drinks, where alcohol is ubiquitous in that society, and the overwhelming stressors of not having a proper job to provide financial support to his children may also drive him to drink because of his low self-esteem and he doesn't feel good about himself and so on, and his frustrations and anxieties. I try to explain in those kinds of cases, even though the respondent is not the qualifying family member, you want to keep the respondent here. It's true he's had arrests for drinking and driving years ago, but he's done well and he's stable here. Similarly, the most important thing to understand in Adam Walsh Act cases, and adjudicators at USCIS repeatedly don't seem to understand this, is that that's the most important consideration for safety. That someone who's not been arrested for 20 years because of this kind of crime or offense against a minor, because he has this supportive and loving environment where everything's going well for him, well, then everything's going to go well for the beneficiary, everything's going to go well for derivatives. And that's something to get across. It's something that I don't think clinically adjudicators always understand, but I often write about it, whether it's one line or a paragraph or two. Nothing is more important than understanding that one single issue. In other words, there are protective factors within the client's environment, and if the protective factors are undermined, then the person's stability will be jeopardized. When working in criminal mitigation, I have what I call the 10 R's of mitigation. And I want to just review them very quickly because I look at them in Adam Walsh Act cases because we have an offense. We have a criminal issue. The first R is reality. That is, don't just look at dispositions. Dispositions drive me crazy in immigration court. It's a one-page nothing. Look at a full narrative of the client's wrongdoing, warts and all. The second R is mens rea. We learn about mens rea in law school as intent, but mens rea should really be reconceptualized as volition. What was the person thinking at the time? Not just their intent. What was their judgment like? Recency, when did the crime occur? The next R is repetition. Was it a one-time thing? Was it repeated? Rung, how serious is the crime? Restorative, has the client righted the wrong? The next R, rehabilitation, has the client changed? Will the client change? This is extremely important, as I said, because many of these crimes have occurred many, many years before. The next R, remorse and regret. Does the client understand and accept his actions? In other words, is there contrition? The next R, roles. Not just what was the client's role in the wrongdoing, but what is the client's role now as a father, as a husband, as a community member, and so on. And lastly, recommendations. What can be fixed, who can be helped? And one of the recommendations I make is that, as I said previously, the beneficiary will be most safe and most secure where the client is most safe and most secure. And that's in the client's home and the client's environment, where over a period of 10, 20 years, he's not committed any other crimes and has lived as a good family and community member. Part of contrition and remorse and regret is also having the client recognize his wrongdoing emotionally and taking responsibility for harm that he may have caused the victim. And this gets to strategic thinking, which I use in criminal cases all the time, but also for immigration defense lawyers when it comes to criminal mitigation. And I want to give you a few examples. One is aberrant decision. That is, did this wrongdoing against a child occur at an aberrant moment? Was it misguided? Was it just a terrible error in judgment? Obviously, it was a terrible error in judgment in the sense that it was committed against a minor. But what I mean is, did it reflect wrong thinking in that particular moment, perhaps because of overwhelming stressors that was occurring to the person in their life in the weeks or months or even years beforehand, so it was kind of an unthinking moment. We want to get across, if possible, that this is a person who is not evil, but has just shown poor judgment in that one situation, that that person has no animus towards society, and it was just a dumb, terrible mistake for which the person has taken ownership. Many of these clients at the time experienced depression, anxiety. They may have been dealing with clinical trauma and all sorts of issues. And sometimes immigration defense lawyers want to shy away from it a little bit because they want to present the client as very emotionally and psychologically healthy without psychiatric problems. To my mind, in many cases, the more explanation, the better, but not to the point where it becomes overly complicated or convoluted. You want the EUSCIS adjudicator, who frankly is not a clinician, to be able to absorb the material and say, okay, I have a really good sense now of why this person undertook this behavior, and I now have a good sense of how this person is really rehabilitated, without the person becoming overwhelmed and they see so many mental health and psychiatric issues, they think, and this will be the bias that they have, this person has never really recovered. If the person has no real psych history, then explain that. Don't leave out a section. In other words, if the person is functioning well and they don't have depression, they don't have clinical anxiety, their interpersonal skills are good, they get along well with their bosses, there's no psychopathy and so on, the person has no real history of alcohol or drug abuse, say so. In other words, normalize the person and show that this person, as a matter of course, leads a safe and healthy life. The Adam Walsh Act cases are considered particularly difficult because of the no-risk standard, which is seemingly impossible to garner from any expert given the highly difficult task of predicting future behavior of a felon, regardless of his apparent rehabilitation. The analysis, therefore, has to be very detailed. It's not a kind of 1 or 2 hour interview. Supporting documentation and evidence is very helpful. Parallel interviews can be very helpful with friends or family members of the petitioner. It's also important to look at situations where there's no danger for one reason or the other to one kind of person or another. And let me give you just a very obvious example. A petitioner is in his 60s and he's petitioning for his wife who is in her 50s and she's beyond the age of becoming pregnant, and he cannot have children for one reason or another. At least in those cases, you don't have a concern that derivatives will be at issue. So the more risk you can eliminate in the case by the special circumstances of the beneficiary or the petitioner, the better off you are. There's something else I want to mention that a lot of people are not aware of, and that is in some of these cases, especially earlier on, and I really learned this from criminal cases, was to bifurcate the case. And by that I mean you have one person, such as myself, doing a criminal mitigation case. You do a psychosocial evaluation in the person's home, all the factors and issues we've talked about. And then you get a second expert to do a paper and pencil objective evaluation based on risk. And hopefully the two reports will complement and balance one another. In other words, in my report, you'll have details about the person, you'll flesh out their life and their functioning and well-being. And in the paper and pencil report, you'll have an objective empirical measurement that will hopefully put the adjudicator's mind at ease. There are many risk assessment tests. What I do when I have an evaluation is I incorporate many of the factors, criteria, and questions in my evaluation through my psychosocial. But as I said, these questionnaires and assessment tools can be used independently by somebody else. So, one question I ask is the USCIS officer really trying to punish the petitioner for their crime a second time, or are they really trying to adjudicate the case in a fair way with regard to safety for the beneficiary? And I think sometimes the officer is trying to continue to punish the client or punish the client a second time around. But as I said before, if you're really interested in the safety of the beneficiary, the USCIS officer really has to understand that the safest thing for the beneficiary is for the petitioner to continue to feel secure. One issue is that sometimes the client is very embarrassed or humiliated by what he has previously done, and that's quite understandable. To me, that's appropriate. That's something I want to see. If I see a client that just dismisses his offense against a minor, that's a red flag to me. I had a case many years ago. It was an initial evaluation. The clients came to my office, and the client just didn't want to talk about it. He had several offenses against 13, 14-year-old females. And I think what I concluded from the initial evaluation, and maybe the client concluded as well, was that he did not really have remorse for his behavior, and he didn't want to talk about it in detail because he wasn't convinced of his wrongdoing. And I did not get the case. The client did not pursue the case with me, and perhaps appropriately so. Perhaps this is a person who should not be petitioning for Adam Walsh Act case because perhaps he's really not rehabilitated, and perhaps it's the kind of case where it should not go forward. Sometimes uncooperative clients are uncooperative for many reasons. There's financial burdens, there's bringing up very embarrassing old things. I just saw a client for an evaluation. We're not going to go through the case, but he was arrested a long time ago, I think about 30 years ago. And the case, there was disposition and so on. But he was horribly annoyed that this had followed him throughout his adulthood. In other words, he took responsibility for it after it occurred and in the years after it occurred. But in his mind, he kind of felt, and I could understand this in part, he felt, look, this is like 5, 10, 15, 20, now 30 years later, he's petitioning for his wife from the West Indies to stay in the United States. And his feeling was like, it's enough already. Like, I've been a good community member. I did my time. I've done what they asked of me. I went to programs, and people are still driving me crazy. And you really have to sit down with the client and say, look, this is not me. This is a standard for the U.S. that the USCIS has. And if you want to pursue the petition as an American citizen for your wife to stay here, then this is something we really need to look at. And sometimes the client needs some time to digest it and allow the client to consider and even reconsider whether to move on with the case in a constructive way. Direct interviews are always needed for these cases. As I said, office visits are not enough. I like to see the home. I like to have face-to-face interviews. I like to see supporting family or friends. Anything and everything is really helpful. I had a case many years ago. This was an Adam Walsh Act case, and the wife was living in, I think it was Dominican Republic. And I ended up seeing her there. The client flew me out there. And I just felt there was a level of interaction that I was able to get with her, even through the translator face-to-face, that was really very informative. She saw me the home. She showed me the home that her husband was renting for her. He was living here in New York. They have 2 kids together, wonderful, happy, smiling, great kids. And the home was very appropriate, safe. And, the wife, obviously she wanted to come to the United States to be with her husband. But, she just spoke about how normal they were. She was aware of her husband's wrongdoing many years before, but she just spoke about how normal the relationship is and their interaction and so on. And it's something I think you can't get with a Zoom call. Personal statements can be very helpful. As lawyers are aware in these cases, document. Really try, and wherever possible, to find areas that would not be necessarily intuitive for other evaluators in regular cases. In other words, a psychotherapist who is interviewing the client would probably not be aware of these factors, would not probably be aware of inherent biases that the adjudicator at the USCIS may have, or how to tackle those biases. And therefore, part of the evaluation, I think, is having a forensic expert examine these cases. And as I said, maybe even bifurcating them so you have someone doing the forensic psychosocial evaluation with any and all mitigating factors, and also having a objective assessment standardized test undertaken by a second expert. I hope this was helpful to you. Please don't hesitate to get in contact with me if you have any questions. Just put in the subject line something that I know is familiar, so I know it's not spam. I'll be happy to answer. I have my phone number and, more importantly, my website. I have to tell you, for all the cases I do, I almost always provide redacted samples. I don't have one in this Adam Walsh Act case seminar because the cases are so different from one another, although I'll try in the next couple of weeks to put one together for those who are interested. Thank you very much for listening today, and press the like button, and hopefully you'll listen to upcoming seminars in forensics for immigration defense lawyers, and also for a series I'm doing for criminal defense lawyers and also civil litigation lawyers. Thank you.